Hello and welcome to our fourth podcast. I'm Peter Doyle, Senior Partner in Doyle Clayton, and I'm here with Dan Begbie-Clench, also a partner in the firm.
Today we'll talk about one of the trickier aspects of employment law, post-termination restrictions or restrictive covenants. We'll be looking at three cases. One highlights the difficulties with enforcing non-compete restrictions. Another one is about the hazards involved with introducing new restrictions during employment. And the final case is about enforcing non-solicitation and non-dealing restrictions in the age of LinkedIn, and whether an employer can protect client relationships even where the information about clients can be relatively easily found on social media. Peter, perhaps you can summarise the basic principles of how the courts view post-termination restrictions.
The starting point is really this. If you're an employer and you want to restrict competition simply because you want to restrict competition, that attempt will be struck down by the courts. But you can uphold restrictions in your favour if, as an employer, you draft those restrictions sensibly and narrowly, and you can demonstrate that you've got something that the courts say you can protect. The phrase often used is that the restrictions must go no further than is reasonably necessary to protect the employer's legitimate business interests, i.e. the employer's interests in their staff, in their customer connections, in their supply connections perhaps, in the goodwill and general confidential information of the business. It's a commonly held misconception that restrictions are usually not enforceable, but simply in the last 20 or 30 years, the process is very much a case that the courts are willing to uphold restrictions in an employer's favour to give the employer some protection of those legitimate business interests when a key employee leaves. Let's focus on non-compete restrictions. These prevent employees from carrying out any form of competitive activity in a certain market or sector for a certain period after their employment ends. These restrictions are the hardest restrictions to enforce in the courts because they may well prevent the employee from earning a living. The courts have described non-compete restrictions as the most powerful weapon in an employer's armoury. Other restrictions which prevent employees from soliciting or from dealing with clients or perhaps suppliers for a period after they leave are generally a little easier to enforce. But in certain cases the court will recognise that those restrictions cannot always give sufficient protection to an employer's business interests and that a non-compete restriction can be justified. An important issue here is that the courts assess post-termination restrictions for reasonableness based on the circumstances known at the time when the restrictions were entered into, i.e. at the beginning of the employment contract rather than at the end.
And perhaps we can highlight a common issue that we see, which is the scenario of an employee who signed up to post-employment restrictions of a minor nature when they started their employment at a junior level, and who has then been employed for so long that the contract becomes out of date, perhaps because their role has changed over time and they have been promoted, or perhaps because the restrictions no longer reflect the reality of the business that they're trying to protect. There's also the problem caused by inserting restrictions which are too onerous or severe for a person at a junior level, and which are therefore unlawful. But then the employer attempts to rely upon these restrictions later on when the person has been promoted. The principle is that restrictions which are unlawful when they are agreed to cannot somehow transform into lawful restrictions later on in the employment relationship when the employee becomes more senior. This underlines the importance of ensuring that restrictions are accurate and reasonable at the outset when the employee signs up to them, and the importance of reviewing and updating employment contracts and restrictions regularly.
This very issue raised its head in the High Court case of Patsystems Holdings and Neely. Mr. Neely started employment with Patsystems in 2000. He was an account manager with an annual salary of £35,000. He was given a contract with a 1-month notice period, and he was asked to sign up to a 12-month non-compete restriction which intended to prevent him from taking up any competing job in that market or sector for 12 months after he left. It was important in the case that this non-compete was not reasonable or enforceable at the time he signed the contract, given his much lower status at that time. He was very good at his job, and guess what? 5 years later, he was promoted to being Director of Global Accounts. His salary was much higher. It was increased to £80,000. His notice period was also increased to 3 months, reflecting his importance to the business. At that time, Patsystems sent him a short letter setting out the main changes to his employment contract, which he was asked to sign to confirm that he accepted these changes. The letter stated that the remainder of his contract was unchanged. What Patsystems didn't do, importantly, was to send him a fresh contract to sign, or to get him to sign up to new restrictions reflecting the broader role that he now had, the more senior role that he had. In 2012, 12 years after he'd signed up to his original contract, Mr. Neely handed in his notice. He went off to join a competitor. Patsystems tried to persuade the High Court to grant an injunction to enforce the non-compete restriction which he'd entered into 12 years before. They did not want him to join that competitor. One of the issues that the court had to decide was whether that 12-month restriction could be justified.
And presumably, Mr. Neely argued that he'd signed up to the restriction 12 years ago when he was a lowly account manager on a much lower salary, so it wasn't justifiable against him now.
Yes, that's just about right. Of course, based on what we've just said, you've guessed it, he did just that. And he argued, it can't be right, it wasn't right then, I was only a junior account manager, that was the restriction that should be assessed at that time. It doesn't matter the fact that I'd been promoted since then. That was the restriction I entered into 12 years ago, and at that time when I entered into it, it was unreasonable and therefore it was void.
But didn't the employer say that it had changed his contract when he was promoted?
He was sent a letter when he was promoted, which said that this letter varied his terms and conditions of employment. And they said that this was akin or equivalent to him re-entering into the whole contract again. They said that he had endorsed the terms of his original employment contract when he accepted that promotion, and therefore that restriction was incorporated to apply to him in the more senior position. The High Court didn't agree. It felt that the 12-month non-compete couldn't be justified, bearing in mind Mr. Neely's status and responsibilities that he signed up to it. He didn't, by some form of magic, re-sign up to it or agree that restriction would now apply to him in his new position. They'd failed to really address that point. The learning point from all of this is that when you're promoting an employee or giving them wider responsibilities or changing their role, you should review the post-employment restrictions at that time, and you should make sure that they are set out very clearly and the person agrees to sign up to them. The problem here is the restriction was a dud from the moment he signed up to the contract 12 years previously. It might have worked in the new or more senior position, but the paperwork didn't deal with the point.
So it seems that a change in the employee's role gives you the opportunity to carry out this exercise and to get the employee to sign up to fresh restrictions to give them a better chance of enforceability. But what about the issue of consideration? How does the employer ensure that the new restrictions are binding?
Well, that's right. The employee should receive some consideration or benefit in return for agreeing to new restrictions. Consideration is an old legal principle, a bit confusing to the non-lawyer, perhaps even to lawyers, under which one party should receive a benefit or payment in return for agreeing to an obligation to the other party. Without consideration or receiving some kind of benefit, the new restrictions may well be regarded as void. It becomes an issue when an employee is asked to sign up to a new contract or they get promoted or something of that nature, when there may not be an obvious benefit. The promotion might be an obvious benefit, but if they're asked to sign up to a new contract, there may be a problem if there are no additional benefits to them.
And what is good or adequate consideration in this case? What should the employee get in return for agreeing to new restrictions?
Much of the old case law says that you should receive nominal consideration in return for agreeing to post-termination restrictions. As I've mentioned, if you're granted a job, you're given a job offer, then obviously the restrictions is part of the job offer. Outside of that, the consideration can take many forms. It could be that when they're asked to sign new restrictions later on, they're given some form of benefit like the payment of a bonus. It could be linked to a promotion. It could be share options. It could be that they accept an appointment as a director. It could be a whole set of things, but there has to be some kind of benefit. In Mr. Neely's case, the consideration could have been his promotion, but the employer's mistake was not making the promotion conditional on him signing up to a fresh contract and new restrictions.
And this takes us to the next case, Reuse Collections and Sendall, in which the High Court had to consider this very point of consideration. Mr. Sendall was a long-term employee in a family recycling business, and he'd never had a written employment contract. It was only in 2012, more than 20 years after his employment started, that he was given a draft employment contract for the first time. That contract contained express confidentiality obligations and post-termination restrictions. One of these was a non-compete restriction, preventing him working for a competitor after he left. Now, Mr. Sendall was initially reluctant to sign up to the contract, having worked without one for so long, but eventually he did sign it in early 2013. It was strange that he did that because very soon afterwards, around a month or so later, he resigned and gave notice that he would be going to work for a competitor. The employer tried to get an injunction to enforce the restriction, to stop him going to work for the competitor. And in court, Mr. Sendall argued that the restrictions weren't binding on him because his employer hadn't given him any consideration when he signed up to the new contract. He argued that the employer needed to have given him some real monetary or other benefit in return for him agreeing to the substantial new obligations that the restrictions contained. He also argued that this benefit should have been substantial and not the nominal consideration that Peter mentioned earlier.
The company tried to argue that Mr. Sendall had been given a benefit. He claimed that the covenants were part of a contractual package which had conferred benefits on Mr. Sendall, including a pay rise. The company said this was the consideration or benefit. The company also said they had continued to employ him, which they argued in itself was consideration and was adequate.
Yes, but the High Court was not convinced by the company's arguments. It was true that Mr. Sendall had received an improved life assurance benefit, but there was no evidence that this was connected to him agreeing to the new contract and restrictions. It was also true that he was given a pay rise, but again, there wasn't any evidence that this was specific to him because other employees had also received pay rises, nor was it made clear to Mr. Sendall that the pay rise was conditional on him signing the new contract. In this case, the court decided that there hadn't been adequate consideration given to Mr. Sendall in return for him signing up to the new restrictions. As a result, Mr. Sendall wasn't bound by the restrictions, meaning that he could go to work for the competitor straight away, and there wasn't anything that the employer could do to stop him.
We can see once again that the employer's mistake was not making the offer of improved salary and life assurance benefits conditional on him signing up to the new contract and restrictions. Sounds a bit like what happened in the Patsystems case. They'd offered the improvements anyway, regardless of him signing the contract. And this really underlines the importance of employers ensuring that adequate consideration is given to employees. And of course, the restrictions are linked to that consideration. Getting an employee to sign up to a new contract which contains new and more substantial post-termination restrictions isn't enough. It doesn't mean that the restrictions will be enforceable. The employee needs to receive some distinct benefit in return as consideration. And there was also an interesting aside in this case, because when assessing the arguments, the court appeared to accept that in this type of case, when an employee signs up to much more powerful restrictions, the consideration or benefit should be substantial rather than just nominal. It will be interesting to see if the courts really develop this line of argument. It could mean that for employers, if they're going to impose quite severe restrictions or far more severe restrictions than previously, they need to think very carefully about what they're offering to the employee. Perhaps they need to offer a far more substantial benefit in return, or at least something which is more than nominal. The question mark is what is meant by nominal or more than nominal.
So to summarise this case, Peter, how can employers best protect themselves?
Well, the best advice would be that when you want to introduce new post-termination restrictions during employment, you should expressly link the new restrictions to the award of some sort of benefit to the employee. It could be a pay increase, it could be bonus, or even a promotion or some new type of benefit. It should also be made clear that the benefit is conditional on the employee agreeing to the new post-termination restrictions. In any event, when an employee is promoted, it's a good time to review and amend any existing restrictions to ensure that they are appropriate for the new role.
The final case that we'll talk about today is on a slightly different theme, and it's about the interaction between restrictions and social media. This is a particular issue for sales and recruitment businesses where employees might make and store many of their contacts on social media, such as their LinkedIn profile. Employees will argue that this means the information about clients and contacts is freely available on social media or the internet. And this is a real issue for recruitment and sales businesses, and it poses a vexed question. If recruitment and sales contact information is easily found on social media, can an employer show a legitimate interest in protecting that information when the employee leaves? It's an issue that the court looked at in the case of East England Schools, CIC and Palmer. Ms. Palmer was a recruitment consultant and she was employed by an educational recruitment agency. They supplied teachers to schools and her job was to match the teacher candidates with the vacancies in the schools, which were the clients of the recruitment business. Ms. Palmer had an employment contract which contained restrictions which prevented her from soliciting or from dealing with the school clients and the teacher candidates for 6 months after the termination of her employment. She was offered a new job by a competitor and she handed in her notice. Her former employer then found evidence that she'd breached her restrictions by approaching schools and teachers, and it applied to the High Court to enforce the restrictions against her. The employer claimed it had an interest in protecting its trade connections with the client schools and the candidate teachers, and it argued that this justified the restrictions being enforced against Ms. Palmer. The employer also argued that Ms. Palmer had built up close relationships with the schools and with the teachers while she'd worked for them, and that if she was free to approach and deal with them straight away, that would give her an unfair competitive edge because she would be able to capitalise on the hard work and the relationships that she'd built up whilst employed by them. Peter, I think you're going to explain what Ms. Palmer argued to defend herself in this case.
Yes, in response here, she said that, in effect, what the employer was saying was completely wrong. The employer did not have anything legitimate to protect. Any restriction can only be justified provided there is an interest to protect. And here they said that there was nothing to protect. In particular, they argued that since so much of the relevant information was now in the public domain, such as on LinkedIn, it couldn't be regarded as confidential. For example, details of candidate teachers could easily be found through LinkedIn, and the schools all had their own websites. Ms. Palmer also argued that she had no advantage over anyone else. There was no loyalty in the marketplace. Many of the schools dealt with several different recruitment agencies, and many teachers registered with different agencies at the same time.
And what did the court make of these arguments?
Well, they rejected what Miss Palmer and her new employer had to say, and in that regard, it was a helpful decision for recruitment and sales companies. Hip hip hooray if you're a recruitment or sales company. The court decided that even though there was easy and wide availability of information about candidates and clients on social media and on the internet, that didn't mean that the employer did not have a legitimate business interest to protect, i.e. the trade connections that they had with the particular clients that they knew. The court ruled that Miss Palmer had made those connections and built relationships with candidate teachers and school clients in her employment, and the employer was entitled to insert a restriction to protect these relationships when she left. Of course, information and contact details can be found online and on social media. The court agreed there was still value, though, in the relationships which the recruitment business had with schools and teachers in being their first choice and in being a trusted advisor and business counterpart.
So this was a positive decision for employers, particularly those whose sales businesses rely on contacts made on the internet and through social media, because it suggests that the courts will not be easily distracted by arguments that employers don't have an interest in protecting those connections with clients and candidates, even where the information can easily be found on the internet. And this underlines that the courts will still recognise that employers are entitled to protect the value in their business relationships that their staff have built up over time. And that brings us to the end of this podcast. We hope that you enjoyed it and found it useful. And of course, if you have any questions, you can call Peter or me on 020 7329 9090, and you should also be able to see our email details on screen now.